Hello, everybody. Some last-minute preparation work there. Welcome to Thursday afternoon webinar, The Joys of Going Live. I am Chris Irons, Strata Advisor with Hines Legal, former Commissioner for Body Corporate and Community Management. With me, Frank Higginson, Partner, Hines Legal. Frank, welcome.
Hello, Chris. Hello, everyone, yet again. Now into the regular routine of these, aren't we?
We should be a bit more switched on than we were last week, although we were pretty switched on for the first one, I suppose. But
first one back after 2 weeks off, I think it was fair. But there were some cracking questions too, so.
There were some great questions last week, and we'll see how this week's goes. So,
yes.
As we said last week, we're going to focus quite a few webinars in the first quarter of this year on the forthcoming new regulation modules. I'm going to try and take a particular topic each week and focus upon that. Last week we talked about, what did we talk about? Oh, that's right, own motions. That's right. This week we're going to talk about both committee and general meetings and some of the changes that come out of the new regulation modules for both those forums. Now remember that Frank and I did a whole of regulation webinar presentation when these were first released last year, and we'll have that link up for you before the end of today's webinar if you want to go back and revisit the whole box and dice. But meetings. Yawn. I mean, meetings, people don't usually get that excited about meetings, but Frank, meetings is how things get done in the body corporate, aren't they?
They are. And I mean, it's ultimately a body corporate, either at committee or general meeting level, is a decision-making vehicle, and meetings are where decisions are usually made. So I think today is committee, general meetings. General meetings are always decided effectively on the papers at the meetings. Committee decisions can be made by votes outside committee, or flying minutes as they are otherwise known, or at formal committee meetings. But either way, that's, I suppose, the primary function of the things. And Chris, there were never any calls to your former office about meeting disputes and decision-making problems, were there?
So I can say this with certainty that disputes about the meetings were the #1 dispute that the Commissioner's office dealt with, and I'm sure that is still the same. And why is that, I hear you ask? Because so many things can go wrong with it. When you think about a meeting in the body corporate context, it's not just the meeting. You've got everything that happens before the meeting. So it's the sending out, the timeframes, the collection of motions coming in. Then you've got the meeting itself. So it's the chairing of the meeting, the tabulation of votes, the counting of a quorum. Then you've got the follow-up, which is the minuting and giving effect to the resolutions, putting aside adjourned meetings or follow-up meetings or anything like that.
Eligibility to vote, quorums,
all of the
special
above.
Resolutions.
Yep. So that is why there are so many disputes, because the more things that you are obliged to do in any one context, the greater the chance that one part of that goes wrong somewhere. Important to note, though, that just because one part of a meeting process goes wrong doesn't automatically mean the whole thing is void or wrong, does it, Frank?
No, and that has been litigated ad nauseum. And so we, get lots of inquiries. Lots of queries, lots of inquiries. I haven't been drinking. I'm having a dry January at this point in time, about meeting procedures and disputes and those sorts of things. And quite often the query relates to, but they didn't do this. They didn't give me the right level of notice. They didn't, whatever it might be. And where adjudicators have consistently got to is, unless there's some, I suppose, serious detriment, some serious disenfranchisement, a real consequence from that particular technical issue, they're not going to knock meetings on the head just for that. And there was a decision that we quote all the time, and I didn't have the link, Chris, because I didn't copy that out beforehand, where a district court judge basically said, this stuff is so complicated, it is almost impossible to get right all the time. And that's right. And even Chris and I sometimes we'll do these completely off the cuff, which is fine. For these ones, we're actually sitting there and running through the legislation together to make sure that we're reading it so that we're not sending anyone up a dry gully with some wrong information. And it is complex, really is.
It is very complex. Why are we saying all of that? Well, because the point is not necessarily to focus on each and every micro provision, although that's important. What is important is best practice. So if you're a committee or a body corporate manager for that matter, and you want to know the best way through to ensure the integrity of results best practice is it. And we're going to focus a bit on best practice towards the end of this webinar today. Today, though, we're going to split it up into effectively committee changes to committee meetings in the new regulation modules and changes around general meetings. Some are applicable to both, but largely they're two kind of separate things. A lot of the changes are confirming what's been happening in practice. So there have been a lot of things that Bodies Corporate have been doing for years, literally, that technically were not supported by legislation. Classic example, Frank, electronic voting.
Absolutely. So in theory, under the old regime, it wasn't necessarily possible, but adjudicators have sanctioned it. And I suppose that's back to creating an environment where people can participate in the decision-making of their own body corporate. So the fact they can't physically get to a meeting shouldn't remove their ability to participate in that.
Yep, that's right. Let's rip into it then. Let's start off with the committee meeting side of things. So first of all, attendance in person at a committee meeting also means remote and electronic attendance under the new reg modules, doesn't it, Frank?
Yeah, provided the committee's resolved that that's okay. So the committee can make a decision how it's going to run its affairs. If the committee says we're going to have these things by Zoom, by phone, by teleconference, Teams, away you go. But if they don't, then you're old school, aren't you? Subject to where we get with the So again, the overlay. And I suppose, Chris, you can put this link up as well. There was a set of COVID regulations released just before the state election. There's a half-hour webinar on that, which effectively said meetings can be conducted electronically until they've been extended to the 31st of April, aren't they?
Yep.
So we've got new regulations that we're talking about today that are the modules commencing on 1 March. We've got COVID regulations that overlay those until the 31st of April. So come the 1st of May, that's when committees really have to make their decisions around how they're going to run electronically in a formal sense.
That's right. And so the important thing now is in the lead up to the start of the regulations is for the committee to look at their processes, and if they haven't formally gone through the process of authorising remote or electronic attendance, now's the time to get into that process. An interesting change, and again, this kind of confirms something that's always been happening, but really puts some rigour around it, is about a representative attending a committee meeting, Frank.
Absolutely. So previously it's really been restricted to, I suppose, to owners almost really, or powers of attorney, to go in along and attending a committee meeting. So the old rules, well, are still applicable in the sense of you need to give 24 hours notice, and then, but now under the new regime, the attendee can be anyone. And dare I say it, Chris is going to be an attendee at a meeting in February as an observer to help a client deal with their particular issues. So it's those sort of things.
I suppose, Frank, the interesting thing about that's before the start of these new regulation modules, but the committee has made obviously what I think is a reasonable decision to allow it to happen. We asked, it was allowed. So those things can happen, but the new regulation modules really put some structure around what happens there. There's some ambiguity.
I would say there would have been a plan B if they'd said no, but under the new regime, you've got a right to go no matter what.
That's right. There is some ambiguity about whether that means the representative and the member attend at the same time. We think it does allow for that, which opens up a whole raft of possibilities, doesn't it? Well, one thing it does do, and a really positive thing, I think, is that I think it allows for a support person to accompany a person to a committee meeting, and that in some schemes where things are really fraught, that actually is really important, I would suggest. So we can be as flippant as we like about all of this sort of stuff, but that sort of thing I think is pretty important. Debtor members.
This is a new phrase, isn't it?
Yeah.
Oh, why not? So there's been one of the big whinges about committee membership previously is you've got to be current regime, you've got to be financial at the date you nominate, and you've got to be financial as at the date of the meeting. That's both you and your nominator. So one of the things that the legislation encourages is self-nomination. So I own a lot, Frank nominates Frank to go on as chairperson, and as long as I'm financial at the date I nominate the date of the meeting, I'm fine.
All right.
What happens now, though, is previously I didn't need to pay my levies for the next 12 months and I'd still be on the committee. But the new regime creates a thing called the debtor member. So if you haven't, or your nominator hasn't, or isn't financial at any time throughout that year, the committee member cannot participate in the decision making of the body corporate. So the real issue for this, as we see it, is that a lot of these things are done, a lot of committee decisions are decided by votes outside committee. So one of the things that's going to be important for bodies corporate or committee members, and particularly, I suppose, body corporate managers in terms of making sure the I's are dotted and the T's are crossed, is that when there are committee meetings, that everyone we know whether people are financial and their nominators are financial before the meeting, and Vox throughout the course of the year that aren't necessarily at the meeting are the same thing, because you can't vote unless you and your nominator are financial.
That's right. So while I think there would be few people who would disagree that this should not be the case, the potential for extra work, extra effort to be put in to ensure compliance, that's actually reasonably significant in some cases. So again, for body corporate managers in particular, this represents something that you really need to be on the ball about straight away, I think, and start planning for it right now. Don't wait until the 1st of March. So I guess it's why we're doing these kinds of webinars, to actually assist in that preparation. Interestingly, those debtor members, Frank, they're still counted for the purposes of working at a quorum, though.
Absolutely. So it's a bit almost like a resolution without dissent. You count the person as being there as a voter, even though they can't vote.
Yes. Yep. Absolutely. Let's talk about Vox for a minute then, Frank, because you and I were having a very robust discussion about this just before the webinar started. So VOC, for those people who are unaware, stands for Vote Outside Committee Meeting. And I think it's like so many things in body corporate legislation, if you are able to step back and think for a moment about the words as they're presented, I think everybody knows by now I'm a bit of a word person, but if you think about words here, vote outside committee meeting. So if you think about that literally for a moment, it's outside a committee meeting. So therefore, Frank, it's not a meeting technically, is it?
No, it is purely a decision. End of story. It's a decision.
So a VOC traditionally is where something to be decided upon is put to the committee via email. That's the really typical way it happens, isn't it, Frank?
Yeah, and I think some people have been doing them electronically for some time, where you send out a yes or no on your vote, you tick yes, and away you go. But yes.
Yep. So now the new reg module confirms that that's the case. The notice goes to all committee members and owners. Must return the votes within 21 days, and it's passed if a majority of votes are received for the motion. If it's not decided in that time, Frank, it is deemed to be?
Deemed refusal, no. So they don't drift. Yeah.
21 days.
Practice.
Yep.
Sorry, mate, I was going to say practice used to be body corporate manager would put on there, please return your votes by this date, you must vote by this date or whatever it is, but that's now been taken out of everyone's hands in the sense of if people are asked to vote and they don't, then if you don't get a majority, it's not passed. And by the same token, I suppose, we get this question quite a bit, if there's a committee of 7 and 4 people have ticked the box to say, yes, I'm in favour, then that motion's done. You don't need to wait in the sense for the other 3 to come back and say whatever they say, because it's passed. Because you've got a simple majority.
Yep, that's right. Importantly, decisions made at a VOC must be confirmed at the next committee meeting, which again, Frank and I had a very robust discussion about that. And there it is. So you must confirm that VOC at the next possible committee meeting.
So I was on the losing side of that argument until we found the provisions in the legislation. But and my assessment of it is, if the committee's made a decision and owners have been given a copy of that decision, to me it's just paper shuffling to actually reconfirm it in the next minutes of the meeting. But the legislation requires it. So there you go.
Yep, absolutely. Let's talk about minutes for a moment. There's a lot of questions always about minutes. What needs to be recorded, how they need to be recorded. I know there are some bodies corporate who think that you have to basically provide a transcript of everything that's said at a meeting for minutes to be full and accurate. Frank, what's your view?
No. We wrote a newsletter on that, Chris, so I think we'll find a way to put that link in the...
Getting that link up now.
Perfect. And that hasn't really changed in the sense of what's full and accurate. Again, back to when you were commissioner and we were doing joint seminars and all that sort of stuff, I think the rationale you produced for this made a whole heap of sense in the context of, if you were an interested third party potentially looking at buying a unit, take your committee hat off for the moment, put your potential buyer hat on, and ask yourself what you would want to see in those minutes that would record the issues and the decisions that the body corporate is actually taking. And that is a good way to look at it. And assuming some people might want complete opaqueness, so there's no transparency. But it really, those minutes, like I said, they're not verbatim, they're record of decisions. You can put in sort of general discussion, you can put in pros and cons, but it really is a bit of a subjective thing in the context of what goes in. But you've got to put that third party view on in terms of what would you expect a third party to be able to identify by the minutes. And that newsletter talks about that a lot.
That's right. So that link is now up there. We'll continue on through a couple of more things on committee meetings. There's a couple of questions there to address before we get on to general meetings. Gosh, time flies, doesn't it? Yep. A quick note about insurance. So for committee meetings, a committee can spend over its spending limit if it's necessary to put into place an insurance policy or pay a renewal, unless it just so happens to be a restricted issue. I'm not sure that it would often, if ever, be a restricted issue. Could be wrong.
Probably a couple of buildings I could name where it might appear.
Yeah, actually, now that you say that, I can think of that. I think that's just a very practical way of doing something that's an essential part of body corporate business. And I'll leave off the discussion of committee meetings with a fun fact, Frank, that has not changed. Legislation still does not mandate a minimum number of meetings. It's a common question, isn't it?
It is, and actually there's another newsletter, I suppose you can tell the topic of things, this has never gone away. So Chris, on our website, there'll be a newsletter called Clayton's Committee Meetings that I reckon I wrote about 10 years ago. That'd also be a good link. And that's really about committees not hiding behind Vox to make every decision to avoid accountability.
Let's rip into a few questions before we get on to general meetings. David, as always, thanks for tuning in. David, I'll put that link up to that court case about complexity at the end. I have now located that. Peter, again, thanks, Peter, for tuning in. Can grace periods influence whether there is a debtor? Depends what you mean by grace period. Frank, what do you think?
I reckon you're financial or you're not financial. Sort of like being you can't be half pregnant. So you have paid what you owe by the day it's due, or you haven't. So if you're overdue, you are unfinancial. So it might be the body corporate has a grace period in the sense of before they pull the trigger on notices of demand, suing people, all that sort of stuff. That's fine, but that doesn't mean you're not unfinancial. From a legislative perspective, you are or you aren't. So if you owe and it's overdue, that's it, would be my bet.
Yep. David, who pays for the administrative costs of a VOC for a lot owner's request between committee meetings? Not the lot owner, put it that way. There's been very clear decisions from the Commissioner's Office about that. And
that's not to say you shouldn't be charging the body corporate for them in accordance with the terms of your engagement, but the committee's there to make decisions. If an owner asks for a committee to make a decision, it's not reasonable, as adjudicators have held, for the cost of that decision to be passed back directly to the lot owner.
Yeah, I'm afraid that's pretty cut and dried. Ian, thanks for tuning in. What correspondence must be tabled at a committee meeting? Anything that's incoming, basically, Ian. That's not to say you have to do anything with it. You have to table it. Yeah.
It's not to say you need to have copies of it attached to the minutes that go out to owners. That's definitely not the case, but I think a notation of what's gone in, letter from lawyers, letter from lot 63, complaint from lot 32 about Chris's pet barking, whatever it might be, should all be listed. That's right. Definitely best practice.
And Anne, thanks for tuning in. And a really good question, confirm, yes. So the VOC decision is confirmed at the next committee meeting, not at the next VOC. That's correct. Yeah. Phew.
Mate, we're going to run out of general meeting time here.
Let's talk fast.
Yeah.
So, general meetings. Electronic voting is okay. But there are a few things that bodies corporate need to consider, aren't there, Frank?
There are. The starting point is for the body corporate to make a decision that people are going to be allowed to vote electronically and attend electronically. That's ordinary resolution. So that hasn't necessarily changed. Well, I suppose it has changed in terms of it's now specifically allowed, but it still isn't necessarily automatic. If the body corporate decides that no one's going to attend electronically, then that's the deal. Away we go. And I think probably the other stuff, and I still haven't, and I can see there being a raft of disputes about electronic attendance, electronic voting over the next 12 months, because the legislation itself isn't prescriptive in terms of this is what it must do and this is what it must allow. Really, the legislation's saying you can use almost whatever platform you like, provided it does these things. It identifies the voter and makes sure that they're financial. If it's a secret ballot, that it protects their identity, that the votes go back to the secretary, which can be the body corporate manager under the new regulations. So they're your requirements. And there are a couple of platforms out there competing for, I suppose, the attention of Strata managers. So it'll be interesting to make sure or to see where some of them probably don't necessarily or might not necessarily dot the I's and cross the T's with this stuff.
That's right. That's right. Also, when we talk about general meetings, quorums are changing. So there is the ability to change by special resolution what constitutes your quorum, but within ranges. So the range is that you can reduce it from 2 to 1 voters as a minimum, and you can change the minimum.
Present in person, yeah.
Present in person, thank you, Frank.
Yep.
And you can change the minimum percentage to a range between 10 and 25%. So
now that's the big thing there. So,
yep.
Sorry, mate. I'll just
no.
That second part, that 10 to 25%, is voters, not lots. One of the really big things people get confused with all the time is a quorum is back referencing the number of voters at the building. So if you've got a building of 100 lots and 50 of them are owned by one person, that one person who owns those 50 lots is a single voter. So for the purposes of a quorum, if the other 50 lots were owned by 50 individuals, there's 51 voters there. So 25% of 51 is the number you need to have a quorum, not 25% of the lots.
Yep.
Sorry.
No, that's a really good point. Thank you, Frank. Also, by ordinary resolution, the body corporate can decide that the voter is present personally if they vote via video conferencing. Again, that confirms what's been happening a lot. But I think technically speaking, you do need to have that ordinary resolution passed. There are actually going to be some instances, Frank, where somebody's corporate just won't want that, or it won't be appropriate. So even though it sounds logical and straightforward in 21st century, not always, I would suggest.
Absolutely. And to me, there's probably the framework for an argument in here somewhere about whether a body corporate's decision is reasonable in the context of allowing or not allowing electronic voting. So when you come back to the motivation of the people voting one way or the other, particularly if there's a block, and particularly on the other side, I suppose, if you've got some people that aren't local that can't get there, and one of the big things we see all the time now is overseas owners, because we've still got, even though you can send agendas now electronically, if you send the old style in the post, it's barely going to get to the people overseas before they have the chance to tick the box and return it in 3 weeks. So that takes away the ability for all of those people to participate in the decision-making process if electronic voting or electronic attendance isn't allowed. So that's a really, there's a Pandora's box.
Remember also, again, that COVID emergency provisions apply here up until 31st of April. But so long as it is to comply with a health direction. And the health direction for Brisbane just got lifted today, or it gets lifted tomorrow morning. So you do have to exercise some particular care about using COVID as your excuse to change the way a meeting is held. Powers of attorney, we've talked a bit about powers of attorney before, Frank, but do you just want to touch upon that one again?
Yep, previously I could go to meetings with powers of attorney from any number of owners and vote for them. Now it's restricted to basically I can only have more than one if I'm a family member. So got a couple of those last ones coming through, believe it or not, Chris, before the end of the regulations change. The biggest meeting I went to, I had 88 of them. So at that stage, I was the decision maker. Anyway, that's gone now.
Yep. And probably one of the other big changes for general meeting is about same issue motions. And we spent quite a bit of time talking about same issue motions in our webinar about the reg modules. This basically same issue motions, Frank, they replace what are now called the motions with alternatives. I think we've talked about this a fair bit. I think this is actually going to make life a whole lot easier doing it this way.
I think when you talk it through, absolutely. I think, wasn't there a Commissioner's Office presentation on that? But yeah.
I'm putting this up.
Yeah, watch that. After that, I think there's probably still some technicalities that will inevitably be required to advise on, but I think in the long run, that should be easier than the current alternative motion process. But that's a real big one for body corporate managers, because it still requires the same, I suppose, identification of the issue being put forward as being the same as something else, which is one of the characterization arguments that come up with that. If Chris puts in a motion and I put in a motion, are they the same issue? Do they need to be framed in that way? If they're not, they can be separate. So,
all right. They're the main things we wanted to cover off on meetings. So with all of that in mind, there's a fair bit there to take in. So let's talk about best practice, Frank, which is what it always comes back to in the end. And the first thing I'd say, there's no substitute for planning. Meetings don't just happen. You have to actually do a bit of backward counting, don't you?
You do. And I think you've always said, mate, it's a political process. And I don't know, the amount of times we have arguments about what's going on in an agenda at a general meeting or concern about it being passed or whatever it might be from whoever we're acting for, when the reality is that the canvassing should have started 3 months before the meeting itself. It's a political campaign. It's the same as we get bombarded with ads from an electorate perspective every time there's a federal, state, sometimes local government election. Controversial body corporate issues are no different. Just firing in a motion, hoping it passes, if you know it's going to poke some bears, is just naive.
Absolutely.
As unfortunate as that might be.
And that leads on to our second best practice tip, which is try and schedule and plan things in a way that maximises involvement and participation. So I know that there'd be plenty of people watching this who do not want a lot of people participating for various reasons, but I'm afraid that the general rule of thumb is the more the merrier when it comes to body corporate participation. So that means, is there a day or is there a time when you're most likely to get engagement and participation? Think about that. Are you scheduling a meeting in the middle of school holidays, for example? Is that going to be, or are you scheduling it at a time when you know, or you should know, that it's going to be tough for people to attend? Try and hold it in an open location. And particularly, I don't know what you think, Frank, but I reckon people should be avoiding holding meetings in somebody's lot. I think you're just asking for trouble.
Particularly in this COVID times.
Yep.
You know what I mean? It's one of those things that neutral ground is always good.
Yep.
So if it's a friendly 8-pack and everyone gets on, maybe if there's going to be some controversial things there, it's sort of asking, and even then evicting people from someone's house if things get a bit untidy is really hard.
It's yuck more than anything.
Yep.
Have some contingency plans in place too. So if you've got people set up to attend via Zoom, great. What happens if Zoom drops out? A number of times our online platforms have dropped out, Frank, over the past 12 months.
Well, we've had a couple of snafus on these things. So
what's your contingency plan? Have them ready to be dialed in on phone if you need to, that kind of thing. A big one that I always harp on about is everyone's address for service up to date. Have you got the right email addresses? Have you got the right addresses for service? When was the last time you checked?
If you haven't checked, I reckon that the thing that I reckon, I'll throw myself out on a limb here as a bit of a prediction. I reckon there is going to be well, at least more than one adjudication application over the next 12 months where people have sent notices by email to an email address where there was a bounce back. So agendas didn't get there. More importantly, levy notices didn't get there. Demands for payment didn't get there. Someone gets sued, and the defence is that has never been my email address. So I think for body corporate managers particularly, making sure you actually don't just delete the bounce backs you get, you check the address and make sure it's right and try to get it right before you start demanding things, because there will be someone come a cropper on that for sure.
Definitely, Frank. Just a couple more best practice tips and then we'll answer questions. Do the online committee training. My former office provides free online training. It's called committee training, but it's actually applicable for everyone. I'm just putting the link to that up now. This is a really good way of getting a good grounding for what you're meant to be doing in any given situation. And then I suppose there's no substitute for being transparent and doing good minutes, is there, Frank?
No. What's to hide? Yep. If not, why not? Why wasn't that there? Why wasn't that explained or recorded? That's the position. Well, that's the position you need to put yourself in to be able to defend those sort of accusations. Because if not, why not?
At some point, it's going to come back to you. It will. It always does. Couple of questions. Sue, thanks for tuning in, Sue. Does all principal scheme inward and outward correspondence have to be included in subsidiary schemes inward correspondence? Why doesn't the service provider not insist this happen?
No, I think that material going to the PBC goes to the PBC. What then goes out to the subsidiaries will be minutes from the PBC that will probably note the correspondence. So let's again, Irons Estate, there's Higginson Estate, frank estate, so on underneath it. Not all of the subsidiaries need to see all of that correspondence because it's not actually relevant to them. So if one of the body corporates over here whinges about whatever their particular issue is, there's no reason to send out chapter and verse every time. So I think, to me, that is a question of making sure that whoever the representative on the PBC is for your particular body corporate knows what's going on and reports back to your building as required.
Very good. Linda, thank you for tuning in. Do the number of votes determine what majority of votes is required? Oh, sorry, do the number of lots determine what majority of
that's
votes?
probably back to that confusion. This is the difference between a quorum and votes. So back to that example before where we had the one owner owning 50 lots, they've got 50 votes. So they're only one voter for the purposes of calculating a quorum, but they are 50 votes for the purposes of any body corporate general meeting. So in effect, on an ordinary resolution basis, assuming they're financial, whatever they want will happen. So yeah, it's one vote per lot, regardless of the ownership.
Sam, thanks for tuning in. Sam, on powers of attorney, can one person hold a power of attorney on his daughter's lot as well as another lot owner who is not a relative? Not under the new regulation modules, they won't.
I don't think so. You're only allowed to hold the one. What I'll do is I'll double check that and just put a link up afterwards, Sam. I just want to be doubly sure. Haven't looked at it for a little while.
But if they're not a relative, then it won't matter anyway, will it?
I think you're allowed to have one power of attorney if you're not a relative, but you can only have more than one if you are a relative. So it's a question if you've got one as a relative and you've got a second one, can you?
Yep.
I'll check that.
Okay, thanks, Frank. And just other Anne, thank you, Anne, for tuning in and your comment there. Millennium is an adjudication on quorum. There are actually a few good adjudication orders about canon quorums. The gold standard is still Sierra Grande for those people who are interested in such things. Gosh,
or grand if you're Australian.
Grand. We've well and truly reached the end of today. Gosh, time flies, doesn't it? Don't forget to like and share. Get the information out there. That ensures that we have the best content for these sorts of things. Next week.
Oh, crikey, I forgot.
A big plug for next week. Next week, a special webinar. You can ask literally any body corporate question you like. So it's a free-for-all next week. Frank and I will be doing no prep because we will be turning up here at 2 o'clock and we'll be taking your questions on whatever you like.
And I suppose post some early, so we've got something to start with. There'll be random us just chatting about the Broncos on Saturday night otherwise.
Yeah, but look, first in, best dressed on that sort of stuff. That's all that I can say on that. We might get inundated. That's fine, but more the merrier. Tune in for that one. That should be good. With that, Frank, thank you as always. Thank you everyone for tuning in. Really appreciate the continuing support and engagement. It's great. We'll see you next week, everyone. Talk to you later.
Bye.
Bye.